Oh, good, you're here. I'm so glad, because I have got something to tell you. We need to talk about the Voting Rights Act of 1965. Were you aware that black women did not get the right to vote free until 1965? And the very first presidential election they ever voted in wasn't until 1969. Whoa, right? I mean, seems like something my school kind of skipped over saying in such plain language. Well, here is what you missed about the Voting Rights Act of 1965. But first, hello, my name is V, and this is my YouTube channel where I dive deep under the desk to find the crumpled paper trails of long-forgotten history, while also gently reminding you that while everything seems awful, there's always a light at the end of the tunnel. Make sure to like and subscribe, because today we're talking about the Voting Rights Act of 1965, and let me tell you something. This is a hell of a piece of legislation. To put it simply, the VRA was created as a means to completely undo the divisions between Northern policies surrounding race when it came to voting, and the more, shall we say, like awful, regressive, terrible, horrible, no good, very bad, racist Jim Crow policies of the South. What's that? Who's Jim Crow? Jim Crow laws were state and local laws introduced in the southern United States in the late 19th and 20th centuries that enforced racial segregation. Jim Crow was a pejorative or negative term for African Americans, and Jim Crow was also a character that was often depicted in minstrel shows by a very unfunny white man in blackface. Yes, they actually used the slur to describe the laws openly. So let's go back. It's 1869. We are 4 years after the Civil War ended. Women are trying to get the vote. The American Museum of Natural History has opened in New York City. The first rodeo has kicked off in Colorado. And also there's this guy out there named P.T. Barnum who is just lying to the public and generally making folks believe anything could be true. Americans were a very gullible, easily entertained, and exhausted public is what I'm trying to get at. But absolutely none of these events were as monumental as what occurred in February of that year. The passage of the 15th Amendment, which finally granted black men the right to vote. Or did it? The language of the 15th Amendment states, "The rights of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race, color, or previous condition of servitude." But think about how that wording is breaking down, right? There's a clear implication that laws cannot be made stating a person cannot vote based on the color of their skin, but it is in no way a declaration that says, yes, black men can vote and you can't stop them. The statement is simply giving the states something they cannot do. They cannot discriminate based on somebody else's race, but they could do a hell of a lot of other stuff to keep them from voting. And since this 15th Amendment didn't outright grant suffrage to black men, the more creatively racist southern states found ways to deny black men the vote anyway. For example, some states required literacy tests from all citizens as a requirement to register to vote, which might make sense to you because you're like, okay, you should be able to research a candidate. We talk about that a lot. You want to make sure you understand their policies and what they've done. A lot of the communication back then took place through writing. You should be literate to vote. But you got to keep in mind, this was only 4 years after the end of slavery, okay? And during that period of enslavement, it was not legal to teach the enslaved how to read or write. Are you picking up what I'm putting down? They very on purpose made a literacy test, knowing that that would be a way to mostly discriminate against black people from being able to vote. But of course, there was a bunch of white folks out there that couldn't read either, and since this law clearly would have affected illiterate white men, a new clause known as the Grandfather Clause was created, stating that if your grandpappy had voted in 1860, which coincidentally was the last election before the Civil War, then congratulations, you don't have to take a literacy test. And yes, that is where the term grandfathered in comes from. The 15th Amendment, for as monumental as it was, just simply was not enough to ensure that black men had the right to vote fairly and freely. But there were people out there pushing for change. The NAACP and the ACLU, organizations that we know about that operate to this day, back then were operating to ensure that the Grandfather Clause and other similarly discriminatory practices were struck down. But there was still that pesky language in the way that the 15th Amendment was written. It simply said what states couldn't do, not what citizens were entitled to. So Time rolls by. White women get the vote in August of 1920, which was in part due to white men feeling like they needed their wife and children to vote the way they wanted them to, as a means to maintain white power against a rising population of black folks and immigrants. And while Mary Church Terrell and Ida B. Wells, two women of color flanked by thousands of other black suffragists, lent their labor and their bodies to the women's suffrage cause, they were not prioritized for inclusion when white women got the vote. Most white women kind of quit the movement after that. They got the vote, they went home to have families. They didn't stick around to make sure their sisters of color got across the finish line as well. So now we're in 1920, white women and white men basically have the vote. Another 80 years or so rolls by. And all during that time, black folks and immigrants are still being kept from the ballot box. They are jailing black folks when they try to register to vote. They are beating them at poll stations. There is open voter intimidation. They are closing voting centers in non-white neighborhoods. There are all-white primaries and poll taxes and a bunch of other stuff, just to name a few ways that they were keeping people from the ballot box. About 100 years after they should have gotten the vote in the first place, the Civil Rights Act of 1964 passes, which prohibits any form of discrimination in regards to race or ethnicity, color, religion, sex, or nationality. Great. We're done. You can't be discriminated on based on your race, so you can't be kept from voting, right? Wrong. There were still monumental hurdles to overcome. And that's why a year later in 1965, we saw the march from Selma to Montgomery, Alabama. Now, I had always wondered, why the march started in Selma. It's seemingly a pretty small town. Well, it turns out that the voting rights protesters who were seeking voting rights knew that the sheriff of Dallas County, Alabama, where Selma was a KKK member and was known for being extremely violent towards protesters. This jagoff used to also wear a military uniform he made up for himself and a pin that said never, as in, you're never going to vote in my county if you're black. So these voting rights activists started by doing a mass voter registration drive of black people in Selma, Alabama, thinking, the old sheriff's gonna come down here, he's gonna cause a stink, we'll get some national press, people will finally listen to us, except this sheriff took it way too far and enlisted the help of horse-mounted KKK members. They beat the protesters so bad that the day became known as Bloody Sunday, and a few people even died. And the public watched it all on their brand new color TVs, and they were horrified. So 2 days later, Martin Luther King Jr. led a march of over 54 miles of thousands of black folks from Selma to the capital of Montgomery, Alabama, to demand voting rights. President Lyndon B. Johnson made the whack-ass cops stand down and brought in the Alabama National Guard to ensure that this march could continue unhindered. And then, when that was all done, President Johnson made the case for the necessity of the Voting Rights Act, which eventually passed the House in a vote of 333 to 85 and passed the Senate by a 77 to 19 vote. So even back then, pretty split. A lot of people still didn't want to see this pass. But this piece of legislation was incredible. The Voting Rights Act of 1965 said no more literacy tests. It also said if less than 50% of an area's non-white population was registered to vote, then the government was allowed to intervene and ask, why is no one registered to vote out here? There was no more poll taxes, and they finally instituted criminal penalties for voter interference and intimidation, which is why, I think the neighbor boy who keeps stealing all the Harris Wall signs needs to face some kind of consequences for his unconstitutional anti-voting rights actions. Very, very ugly stuff. Now, within 4 years of this act's passage, nearly 1 million black voters were registered, including 50% of the black voting age population in every single southern state. That is incredible. And the number of black elected officials in the South more than doubled. It went from 72 to 159 after the 1966 elections. In 1965, when the VRA passed, there were only 6 black members of the House of Representatives, and there were no black senators. But by 1971, there were 13 members of the House and 1 black senator. And over the course of the following years, disparity rates between white and black voters dropped from an all-time high of 30% disparity down to just 8%. It cannot be undersold just how friggin' monumental the VRA was to democracy, especially for men and women of color everywhere. And everything was happy forever and nothing bad ever happened with voting. Wrong. No, of course. Just this past September, a conservative man in Ohio made a post on Facebook that said people who have signs on their front lawn that say they are supporters of Kamala Harris should have their addresses added to a registry. I'm sorry, sir. What are you going to do with those addresses, mein Herr? Like, I am very uncomfortable with that idea. Thankfully, public backlash was swift and this guy eventually deleted his post. So what's the big deal, you might be asking, right? I mean, inflammatory rhetoric from a conservative on Facebook is like pretty common, especially on Facebook. Number one, this wasn't just any conservative dude. This was the Portage County Sheriff of Ohio, who was literally in the process of running for re-election. And number two, the sheriff made an impermissible threat per the Constitution. The Constitution says you cannot threaten people just because they're saying they're going to vote or who they're going to vote for. Per the language of the VRA, any act that constitutes as voter intimidation, which this certainly would, is completely forbidden. And if you want to know, well, is anybody above this language, or what about him being a police officer? Like, he didn't specifically say what he was going to do with the registry. Let me read you the language from the bill so you know exactly what it says. It says, quote, "No person, whether acting under cover of law or otherwise, shall intimidate, threaten, coerce, or attempt to intimidate, threaten, or coerce any person for voting or attempting to vote." I mean, it's pretty plain language there. There's not a lot of room for loophole. And if you're wondering, well, I encourage people to vote all the time, is that okay? It's okay to encourage people to vote. It's okay to encourage them to vote for a candidate you want. It's not okay to say, if you don't vote for the candidate I want you to, I'm going to do something bad to you. There could be no threat, okay? You can express your opinions without threatening people. Now, the VRA is great, but you might not know that we actually have to renew it every couple of years. And yes, of course, the Republican-controlled Congress did not renew it. So there's some language in the Voting Rights Act that some folks have a particular problem with. In particular, the people who are like, I don't like that people have an equal right to vote for me, want to do away with Section 11B of the VRA, the section that essentially outlaws voter intimidation. They are also bastardizing some of the protections that the VRA offers. Now, back in the 60s, when Black people started to vote, that didn't mean that everyone was like immediately super nice about it. And there was a provision that said the states with low Black voter turnout could be federally monitored so that discriminatory voter laws could not become a thing. Basically saying, hey, if we're noticing that not a lot of Black folks are voting, we're going to assume that they're being intimidated and we're going to put a monitor in to ensure that these people feel confident going into vote. Well, there are some conservatives that are using that part of the law to hire partisan poll workers to intimidate voters instead. And they're saying that this is protected work. They're saying that these conservative Republican, whatever, poll workers need to be in there to ensure a free and fair election for conservative voters who are not under threat, but who perpetually make themselves a victim, okay? They're also trying to make things like being a good neighbor considered voter interference. You may have seen a law in Georgia that recently got overturned where Georgia said you can't give people food or water if they're in a long voter line because that could be considered bribery or intimidation. They weren't sure which. And the truth is, all of this nonsense aside, there is nothing compared to what happened in 2021 with Brnovich versus Democratic National Committee. This is the case where the Democratic National Committee went up against the state of Arizona, who at the time were represented by Arizona Attorney General Mike Brnovich for two reasons. First, in Arizona, voters who had accidentally voted at the wrong polling place would get their entire ballot tossed out instead of being told like, you're at polling place A, you need to go to polling place B. They would just snatch their ballot and be like, oops, you don't get to vote now, and that's not cool. And second, Arizona has a number of restrictions with regards to vote by mail, particularly when it came to ballots being turned in by a friend or a neighbor. Here's why that is such a big deal. Arizona has one of the biggest Native American populations in any U.S. state. And according to rockthevote.org, the Navajo Nation at the time was arguing that Arizona not allowing a friend or neighbor to turn in the ballot was criminalizing ways in which Navajos historically participate in early voting by mail. Due to the remoteness of the nation and lack of transportation, it is not uncommon for Navajos to ask their neighbors or clan members to deliver their mail, and within that mail also their ballot. So an Arizona law that would ban someone from helping to return a tribal member's ballot is an unfair burden, and it suppresses the vote of disabled voters as well. And, of course, when this made its way to the Supreme Court was like, that makes a ton of sense. Oh no, they sided with the voter restriction. Crap! Great. Come on. It was a 6-3 decision that saw the Supreme Court rule that any burden on voters of color is too modest. Basically, the Supreme Court acknowledged that discrimination exists, but it's not a real issue because it's not enough discrimination for that discrimination to matter. So the fact that it just affected a couple Navajo elders or a few people from a certain county, we can't be concerning ourselves with that. That amount of discrimination is not enough to merit a response. I don't know, man. But in Samuel Alito's words, and I'm paraphrasing here, everyone has an equal right to vote. It's just that sometimes voting is more inconvenient for someone else. I can't. So if you're not seeing the problem here, I want to be clear that this is a direct attack on Section 2 of the Voting Rights Amendment. That's the part that prohibits voting practices or procedures that discriminate on the basis of race, color, or membership, as the DOJ describes it. The Navajo Nation, I think, very clearly made the case saying this is discriminating against us based on where we live and our membership, and the Supreme Court was like, not enough. But the waters have been muddied in regards to what discrimination even is in a legal sense, and there have been alarms sounding for years now that the Supreme Court is not interested in protecting voting rights anymore. Things have gotten so dire that NPR reported that civil rights groups are now actively avoiding the Supreme Court. In July of 2024, attorneys led by the American Civil Liberties Union let a filing deadline pass at the U.S. Supreme Court, choosing not to ask the justices to review a controversial lower court ruling that threatened to help end one of the main ways for enforcing the landmark law's protections against racial discrimination in the election process. The groups now say that they are considering other avenues for challenging a redistricting plan in Arkansas because they don't trust that the Supreme Court would rule fairly, and they believe that it would be more harmful to Black communities. The Voting Rights Act is being gutted every single opportunity possible by politically divided Supreme Courts or by an extremely dysfunctional Republican-led Congress. It is getting broken down one section at a time to the point that people don't even want to take their arguments to the Supreme Court anymore, and that is just bananas, right? And the other thing that's like maddening is not like the Supreme Court is like consistent on when they decide that discrimination matters, because in 2022, Allen v. Milligan argued that Alabama's congressional map was neutering the power of Black voters by districting mostly Black voters into just one district, with others being sent into smaller factions in just one district. Shockingly, the Supreme Court agreed in a 5-4 split where Brett Kavanaugh was the deciding vote. I know, Mr. I Like Beer also liked helping Black voters in Alabama this time. We'll take it, you know what I mean? And I'm really glad for that because Alabama at least has 2 predominantly Black voting districts. It should be more than that, but, we keep fighting. Now, it's not that the Supreme Court is always on the side of affirmative action. In fact, after this decision saying that the Alabama districts were too gerrymandered, they overturned affirmative action. And Brett Kavanaugh was the deciding vote again. So Brett Kavanaugh cannot be trusted when it comes to deciding what is discrimination or not. He's still racist in my book, and we continue to live a fever dream. All jokes aside, the constant attacks being levied against the Voting Rights Act are definitely cause for concern, especially as long as we have a divided Supreme Court. And clearly the issues of voter suppression are viewed more as partisan issues than existential ones. Even though the Voting Rights Act was the law of the land, it is not bulletproof. Attempts have been made to strengthen the VRA over the years, and plans have been proposed to reformulate things like preclearance, but nothing has stuck. So what do? And I really just want to say, vote and knock this microphone over and be done. But that, of course, is ironic to the discussion we're having and not enough. There is one popular proposal out there called the John Lewis Voting Rights Advancement Act, which would ensure that people have better access to the ballot box and definitely keep voter intimidation laws in place. This seemingly miracle piece of legislation isn't without its challenges. It has passed the House in 2021 and 2022, but they straight up filibuster it in the Senate. Now, there have been some people who say if Kamala Harris gets elected president and we have the Congress and the Senate, they will vote to end the filibuster, which I am personally in support of. I'm also really proud to say that at the state level, a lot of really great work is doing to make sure that people don't get disenfranchised. Like here in New York in 2022, we passed a law that reinstated this thing called preclearance, which means that any kind of voter crackpot nonsense that somebody wants to propose has to be proven in court to be constitutional before they can pass a law making it a thing. So they can't come up with like new voter intimidation tactics and pass it through the state legislature and make it a law and then send it to the court. It has to be decided in a court first to ensure that it wouldn't harm voters. And our favorite mitten-shaped state, Michigan, also passed a Voting Rights Act. On September 17th of 2024, the Michigan State Democratic majority passed legislation to establish the Michigan Voting Rights Act. Quote, building on the progress of the Federal Voting Rights Act of 1965, the Michigan Voting Rights Act would set additional protections in place at the state level, which would shield voters from attacks on exercising their right to vote. Specifically, the act is intended to provide avenues for voters of color and protected classes to defend their right to vote and access fair political representation. The MVRA would prohibit local government or state agencies from imposing any law, practice, policy, or method of election that would lead to a disparity in voter participation between protected class and other members of the electorate that would impair the ability of a protected class to participate in the political process. All that to say, you cannot mess around with the vote in Michigan. And look, if it can happen in Michigan, it can happen anywhere. And it is not lost on me that Kamala Harris, who was born in 1964, was born without free, fair access to the ballot as a Black woman. It humbles me to learn about these things, and I hope that you learned something here today too. Thank you for learning about the Voting Rights Act of 1965 with me.